All right, folks, we're going to head back to court in just a minute, but first I want to bring in our guest for this hour. Joining us, criminal defense attorney, former prosecutor David Bruno. David, great to see you as always. Thank you so much for joining me tonight. I want to begin with the defense by Hernandez. This idea that, hey, you know, yes, I was there. Yes, we intended to rob the place, but I was not, and there was no discussion of any kind of murder. And we know in Michigan, it's required for prosecutors to show that in felony murder, both parties have to have this idea of what we call malice. They either intended it or the situation that they created was so dangerous, it was reasonable to assume that something like this would happen. What do you make of those arguments, considering some of the facts that we have in this case for Hernandez in particular?
Yeah, absolutely. And that's one of the reasons why we have dual juries as well, Michael. You have separate juries here, and oftentimes for the states that do allow that, it's because of the agnostic defenses like we have here. One defendant pointing the finger at the other, and sometimes when there's statements, it brings up this problem with the confrontation clause, because if one defendant makes statements against the other, they have a Fifth Amendment right to remain silent, and then that other attorney can't cross-examine the statement. Hence, a brutal problem under the United States Supreme Court. On the issue of felony murder, Michael, most states across the country have a almost strict liability felony murder. Meaning that if you're a co-conspirator to a home invasion or a burglary like this one, it wouldn't matter what your level of participation is or whether or not you intended death or serious bodily injury or not. Michigan, on the other hand, had a Supreme Court case in its state in 1980, People versus Aaron, that went away from that strict liability standard and added the malice. There needs to be a specific defendant, like Hernandez, would have to intend to commit murder, death, or serious bodily injury, or in the circumstances that would lead one to believe that those two things would happen. So here, Hernandez is pointing the finger at the co-defendant, saying, look, we intended to burglarize. We intended to go in and steal. But under no circumstances did I intend to commit the murder or the death. And if believed, it could be a not guilty on that top count, first-degree felony murder. And that's what Hernandez is trying to do with his defense.